All right. Now we're ready to go. Now is the time set for oral argument in cause number CACV 140603, DMARC, DMARC 2006 CD2 Indian School LLC versus Bush Realty at Steel Park LLC. For your information, these proceedings are being audio and video recorded, so barring any technical problems, you should be able to critique yourself on YouTube in a couple of weeks. Counsel, each side, as is the rule here, will be entitled to 20 minutes, and we would ask that you respect that time period. We probably won't, but we're going to ask you to. The timer located on the podium will let you know how much you have left. An appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can try and avoid taking up all your time. However, ultimately, reserving your time is your responsibility. We have reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to the argument. And we tell you that to give you the chance to kind of orient your argument as you deem appropriate. When you come to the podium, each of you, I would ask that you state your name and who you represent. And with that, counsel for the appellant, you can begin.
Good morning, Your Honors. John Lohr on behalf of Samuel Weiss et al. I'm going to try to reserve 5 minutes of my time for rebuttal, respectfully. If it pleases this court, the court must remember that this is an appeal from a granting of a motion for summary judgment partially, where the standard of review is de novo. And that is very important because the findings were not from a trial. They were from a summary judgment. And this court must look to whether there was a genuine issue of material fact or whether the law was applied correctly. And the court must look at the facts in the light most favorable to the appellant, my client. The pivotal issue that must be decided in this case is whether a guarantee contract or a purported guarantee contract can be binding on the purported guarantor when the lender failed to present any evidence at the trial court that the actual terms of the contract itself were available or presented to the purported guarantor at the time of signing. In this case, that is exactly what happened.
Now, is that, counsel, is that the responsibility of the person laying the contract down for signature, or is it responsibility of the person signing the signature line? Well, to say, I've read the document, I'm now prepared to say that I agree to it by application of my signature. Whose responsibility is that?
Well, Your Honor, I think it's even more basic than that. You have to go to the basic principles of contract law. You have to look at whether there was an offer. You have to look at whether there was an acceptance. You have to look at whether there was consideration. And the key thing is the fourth thing. You have to look at to whether there was sufficient specification of the terms so that the obligations involved can be ascertained.
And how do we typically determine that that has occurred?
So, well, you've got two parties coming together. They have a discussion. They present contracts. They sign documents.
But how do we usually determine, in looking back at these things, that in fact those elements must have come together?
Well, we have to look at the facts of this case.
Don't we have to look at whether or not they signed the agreement?
Just by signing a signature page alone, without the terms, we do not believe that is sufficient to bind a purported guarantor.
So, but your client was willing to accept the money by signing an agreement to take the money without reading the loan. It's just that he doesn't want to be bound by the guarantee because he didn't read the guarantee.
Respectfully,
is that
Your Honor,
a fair statement?
No, Your Honor. Respectfully, it's not, because my client didn't take any money. This was a 1031 exchange, and it was also done on behalf of a corporation, an LLC.
But he entered into the deal to gain there's compensation. There is an exchange of consideration. He signed off on that, even though it's for a corporation, without reading it. He didn't then turn around and say, I didn't read it, so here's your money back.
We need to go back further. We need to go back even before the loan was made. Mm-hmm. If you look at the beginning of this case, there was something called a tenants in common agreement. According to that tenants in common agreement, Bayman, his company Empyrean, and my client's company Bush Realty set up to do this 1031 exchange. And in that document itself, it talks about certain things. If you look at the document itself, you should go back and look at Section 4 of the Tenants in Common Agreement. That talks about loan documents. Nothing in there talks about how either Bayman or Weiss would be signing a personal guarantee.
But he signed a paper that identified him as the guarantor and had guarantor and his name on the paper.
But we have to look at his reasonable expectations. Again,
Wait a minute. Reasonable expectations. It says guarantor. There's a line in his name, and he signs as guarantor on the line that has his name attached to it. What is the reasonable expectation there?
we have to go back further. Again, what is he guaranteeing?
Is there a confusion as to the guarantees? Were there multiple guarantees, and he didn't know he was signing this guarantee?
The record reflects that there were a set of signature pages that were provided to my client, a stack of signature pages. They do many business deals this way, and unfortunately, my client walked into there believing that he was just signing on behalf of his company. He was told he was signing on behalf of his company before he walks in there. He has the Tenants in Common Agreement, which indicates there's no personal guarantee whatsoever. This is not a case where the lender calls up my client and says, hey, we're going to give you this multi-million-dollar loan, but you got to come in, you got to sign a personal guarantee, we got to look at your personal finances. That's not what happened. The lender didn't call my client. It was Bayman who called my client and said, hey, I need you to go to my law firm. They're going to present you with documents. My client goes in. He doesn't even meet with anybody. He's put into a room. He's given a few documents to sign, a few pages to sign, just signature pages alone. He's never presented any of the loan documents. And then, lo and behold, 7 years later, when DMARC takes over the loan file, they open the file, and there's a personal guarantee in there.
Well, why in the world would a sophisticated businessman just sign documents not knowing what the heck they are?
Well, Your Honor, I think we're placing too much of a burden on my client. The lender has responsibility here, too. The lender, again, it goes back to basic contract terms. There has to be sufficient specification of the terms so the obligations can be ascertained.
Fair enough. And they would be contained in the documents. What case
But there were no
says-
documents.
Well, there were documents. They just were not given to your client when they signed them. He didn't ask for them. They didn't give them to him. Is there a case that says, what's your best case that says, it is the person providing the documents to the person who's signing it, or providing the signature page, they have a duty to get, without being asked, to give him the underlying documents that he's signing? Is there a case that says that is an affirmative burden upon the other party to give it when no one's asked for them?
Respectfully, Your Honor, before I answer that, there's one factual thing that I think needs to be pointed out.
Okay.
There is nothing in the record whatsoever that reflects that if my client would have asked for the personal guarantee at the Dreyer Law Firm, that it was available, that it existed.
But he didn't ask for it.
Well, even if he would, it's their burden of proof.
Why do they have
Why didn't he get up and walk out?
Again, he was handed a stack of documents and he signed it. But again, in order for a contract to be formed, it's their burden of proof to show that the contract existed.
But
it's their burden of proof to show that they provided terms.
But we
There's
also,
no evidence in the record. This is not. I'm sorry, Your Honor.
No, go ahead. I was interrupting.
This is not a trial. This was not done by a trial. This was done through a motion for summary judgment. Clearly, there are genuine issues of facts in dispute. And now to answer your question, I'm sorry, Your Honor.
Thank you. What's the case? What's your best authority?
Unfortunately, there is no case. But again, we have to go back to basic contract law. It's an obligation for both parties. It's not just my client's obligation to say, give me the terms of the contract. This is a lender who wants to bind my client to a personal guarantee. I mean, what are we guaranteeing? Let's say that my client signed the personal guarantee. It's still their obligation to identify what the terms are, to provide what the obligations were. I mean, he could have guaranteed my client entered into this contract on behalf of his company, taking a 25% interest in this property, 25% in this property. So if it was a personal guarantee, what's to say he shouldn't have guaranteed just 25% of the loan, or 25% of the smaller portion of the loan, which was ultimately what this purported guarantee provides?
What's to say? Concede to the terms of the document that the signature page was going to be attached to when he signed that signature page without asking to see the document itself?
It's our position that he did not, because again, they didn't provide the terms. How did he know what he was agreeing to? He walks in there thinking he's signing on behalf of Bush Realty and Bush Realty alone.
Well, that's not what it says on the guarantee, the signature page on the guarantee.
We recognize that. Again, he
Tough
probably should have
tough
looked at it a
argument to
little
make.
closer. He didn't look at it that closely. He was just handed documents. But again,
Whose responsibility is that?
it's the lender's job
To make sure he looks more closely.
Well, we don't even know if the documents were available, if he would have asked.
No.
And these create factual
On the
issues.
signature page. Whose responsibility is to make sure he reads the signature page, even if the signature page isn't attached to the guarantee?
While my client could have avoided the situation, the lender could have equally avoided it by actually providing full documents at the time of closing, like a normal lender does. I mean, it's absurd for this lender to come in to this court and say that Weiss should be bound by a $4 million guarantee when the lender itself has no evidence that it was there at the closing, has no evidence that it negotiated the terms, has no evidence that it presented the terms to my client. Just because 7 years later, when they go to foreclose this property, the assignee of this loan opens the file and there's a guarantee contract doesn't mean that's binding on my client.
Well, counsel, let's assume for the moment that the lender did all that, put the stock of documents on the table, your client signed. I can imagine you would be making the argument, well, there's a big stack of documents. I didn't have time to read and understand them all. I just signed them.
Every single case in Arizona that talks about enforcing contracts when you sign a piece of paper, every single case, the loan documents, the contract itself, the guarantee, whatever it was, every single reported opinion that's in this state and elsewhere talks about the contract terms being presented at the time. There's not a single case in all the United States that we could find.
Counsel, isn't that because sophisticated money people in this situation wouldn't sign a signature page without wanting to know what it was attached to?
Again, we have to look what was in his mind. He goes in there thinking he's signing on behalf of Bush Realty and Bush Realty.
But even then, he's committing Bush Realty,
sure,
and yet he's committing Bush Realty to something he doesn't even know what it is.
well, he knows that it's a loan in conjunction with this 1031 exchange for this apartment complex here in Arizona. That's what he knows. He knows it's a 38 he's told by Bayman and the attorneys that it's a $38 million loan. That's what he knows. He doesn't, but he's never told by Bayman, by Dreyer, by the lender. Nobody says, hey, just so you know, you're going to be signing a personal guarantee where if there's fraud or bankruptcy, you could be liable for the whole $38 million. Oh, and then if there's not, you're just on the hook for just $4 million. Nobody says that to him. Is that really the law we want to have in this state?
Well, I've got two questions. So, are you saying that had the lender brought in the documents and put them on the table, and otherwise it's the same case, you wouldn't be here making a variation of the same argument?
I think we would be on the hook. I think we don't have the arguments in that case. In that case, the terms are provided, the obligations are known, so the obligations are ascertained in that case. But that's not what we had here.
And then my second question is,
and the case law supports that, by the way, Your Honor. All the cases talk about that. And if that was the case, we wouldn't have been in court.
If the parties negotiate a deal, they negotiate it hard, and the deal's all done, and then in a week or a month later, however long it takes, all that we need is the signatures. So are you saying that before the person signs, everyone's got to come back into, now you understand that this is the deal, and we got to run through all of the terms of the contract, or else the signature isn't valid?
Are you saying that they talk about it, but the actual terms itself are not there, and then he signs a signature page?
Yeah, I guess what I'm asking is, are you saying that the contract has to be read to the person at the time that they say no matter how well informed he was a week ago about the deal that was struck.
Well, I think that's a tribal issue of fact that a fact finder has to find to determine if when they sat down, when they negotiated, was there a meeting of the minds? Was there were the terms specifically identified so they could understand the obligations? And if we had that case, which we don't, then this case would be completely different. But that's not what happened in this case. There were no negotiations. There were no discussions. There was no meeting of the minds here.
Counsel, I'm having a hard time with your argument. And you may be able to help me on this. What I seem to understand you're saying is, and we're guided by the cases in Arizona that says, you don't read the documents, you don't read a contract. The courts are not under the duty of relieving parties of the consequences of their own gross negligence. That's what the Brad Levy Industrial Commission says.
Sure.
So, and if I understand you're saying, well, it's one thing if the documents are placed on the table. I don't have any case that says they have to put the documents on the table. But it's one thing, and I'm having a trouble with this distinction. If they put the documents on the table and my client said, not going to read them, I signed off, he's bound.
I agree with that. And
if they don't bring the documents in and he doesn't ask for the documents and he signs off, then he's not bound by them.
But that's where this case is in kind of in the cloud here, because I think there are genuine issues of material fact on whether or not those terms were even available. It was the lender's burden of proof to demonstrate that this contract was formed. Well, the lender had no evidence in the motion for summary judgment to show that the terms were at the dryer's office, that they had provided the terms at the dryer's office. So even if my client had asked for them, we have absolutely no evidence that the terms and conditions were provided to anybody so my client could get them.
And if your client, and this gets back to the burden question I think Dr. Jones started with, if your client had said, hey, I want to see the documents, and they said, nope, not going to show them to you, and he signed anyway, that may be an issue. That's an issue because even Bradley talks about other than the other party's misconduct that he didn't know.
It's interesting that
I don't see a case that says they have to provide them with copies of the documents even if they're not asked for. And I haven't found a case that's their affirmative burden, the other party's affirmative burden to provide them with copies of the documents, or that a case that says, well, if you don't ask for the documents and you sign, you're not bound.
Well, I agree there's no reported opinion on that, but I will point out in the Savaco Masonry versus Home and Son construction case that does talk about, it was a construction case, it was oral contracts, and ultimately the court found that there was no meeting of the minds and the contractor was not bound. And the court very clearly held that a sufficient mutual understanding as to all the terms of the contract did not exist and there was not a contract. The court held that even a contract implied in fact is dependent upon mutual agreement or consent. We note that even an implied contract requires a meeting of the minds. Here we have no meeting of the minds. We have no terms. And at this, unless there's any other questions, I'd like to reserve my last 3 minutes for rebuttal.
I do have a problem with that because I think we are talking at different levels, and that's not denigrating your argument at all. But it seems to me that the theory that if someone signs something without reading it or without seeing it and reading it, and not asking to see it, it means that we assume that he is bound by the terms of the writing.
But I don't think I don't think we want contracts to be formed this way in such a fashion where the terms are not provided. It's going to put contract law on its face, and it's going to create a huge imbalance for people that have a lesser of a bargaining power. If a lender comes in and says, whether you're buying a home, whether you're buying a car, whether you're buying a boat, whether you're entering into a gym contract, they come in and say, hey, guess what? We've got you approved. We're gonna sell you this thing. Just sign the signature page. And then later on, when things don't go right, you get involved in a lawsuit and you get these terms of this contract that are nowhere near what you thought you were getting. So why is the burden simply on my client? Again, we're talking about a motion for summary judgment here. It was their burden to prove that a contract even existed. They couldn't. They couldn't show the terms. They couldn't show any negotiations. All they could show was, hey, we get this file when we bought the loan. Well, there's a personal guarantee in it. That's all they could show. But that alone is not enough to bind my client, and it should not be enough for this court to bind my client and create new law. And that's what we'd be doing here. I mean, we'd be saying that the obligation is completely on the obligor, and the obligee has no obligation to provide the terms. I think that is a very dangerous ground for us to be walking on. And I've got a minute left, so I'll reserve that for rebuttal.
Good morning, Your Honors. Thank you. My name is Mark Conrad. I am on behalf of the plaintiff appellee in this case.
Counsel, we've just heard that it was your responsibility to not allow Mr. Weiss to sign that page until he could show you that he'd read the terms and the contract and agreed to the terms. Do you want to address that?
Sure. I also heard that his multi-million-dollar client was a party of unequal bargaining power. The reason why that is wrong is because the terms were agreed to. The terms were assented to by the signature. There was one thing that demonstrated the assent in this case. It was this. We also proved up the terms of those contracts through deposition testimony. We deposed and showed the guarantees to the other co-guarantors. One was Mr. Taylor, who was a 30B6 witness for the corporate guarantor. The second was Mr. Bayman, who was the same individual who called up Mr. Weiss, according to Mr. Weiss's counsel, and said, come down here, sign the contract. Okay? Again, the issue is not were the terms agreed to or understand. They were understand, they were agreed to. Indeed, the original loan file in this case and every piece of paper in that loan file were forensically examined. Actually, no, I'll mistake, the promissory note, the guarantee itself. There was a certificate of guarantors that was forensically examined by their own handwriting analysis. They verified the signatures. This was not a forgery case. This was not a fraud case. And if there's yet another fact which puts an exclamation point that they knew and understood and agreed to all the terms, whether they chose to read the documents underlying them or not, is the fact that every other document except for the guarantee they believe and understand and agree are enforceable contracts in this case. It is mere sophistry to say, wait a minute, I'm going to go into a room, I'm going to sign a bunch of signature pages, and I get to pick and choose which of those signature pages, which are affixed to which documents, are binding contracts and which are not. And that's exactly what they're asking for in this. And even if you look at the signature pages in this case, they are a problem. And as you looked at the signature pages identified by the court, the signature page on the guarantee itself reads Samuel Weiss, guarantor, individually. There can be no mistake. Apparently he could see the line, but he chose not to read the words above it and below it. Even more importantly, one of the documents, which again was forensically examined by their own expert and which bore his signature in original ink, was the certificate or the guarantors. And that's contained in our appendix of appeal, but it read, the undersigned believes that the transactions contemplated by the guarantee documents are in the best interest of the guarantors and do not impair the rights and interests of his creditors. Guarantors by, and there's Samuel Weiss, and there's his signature. Again, Your Honor, this argument that Mr. Weiss did not want this transaction, wrong. That he did not understand he was a guarantor, wrong. That he did not affix affirmatively with a pen his original ink signature to all of the loan documents, wrong. The fact that he wants to enforce selective loan documents because it benefits him for a 1031 exchange. How can you argue that the same act of assent to a loan document, to a promissory note, that results in the transfer of $38.5 million is good enough for that, but it's not good enough for the guarantee, which he admitted in the certificate of guarantor that he was in favor of? Again, there's no evidence from all of the circumstances relating to the execution of the loan documents that there was any fraud, any deception, anything. It was just they wanted the money, they signed the documents. Had he asked for the originals, he could have certainly had them, but he didn't. So to speculate what should or should not have been as based on that has no basis in evidence in this case.
Your opposing counsel has
Sure.
basically said there's no case out there that says you have the burden when not asked to show the person the documents he's signing. There's no authority for that. I mean, your comment about, well, I think part of this gets down to who had the burden. As Dr. Jones wisely put it, who has the burden? And it seems to me if I'm signing something, I've got the burden to say, let me see what I'm signing.
Sure.
And not, well, gee, I can show you that I was going to offer you. That's the triggering thing, the triggering event. Let me see the documents. But what do you do with the idea of, does this make bad law in the sense that you go in to rent a car or you go in for a gym contract and they tell you about what a great deal it is. And they say, oh, okay. And they say, here's a signature page. I mean, that person's just unprotected?
Your Honor, the person is not unprotected because unless someone forces his hand onto that page.
But he signs it, and you tell him X.
Okay.
His reasonable expectation is, I'm signing a gym contract for a year at $25 a month.
Right.
And then 2 months go by, and he finds out he's signing a $200 a month contract for 10 years. He has no remedy
Your Honor,
because he signed it?
that's the law in Arizona. And not to use your analogy, it's very akin. The two big cases that were cited by the trial court were the Hoffman case and the Bradley case.
Right.
And in the Hoffman case, I believe there was a guarantee, actually. And the evidence, if you review the facts of the case carefully, the guarantor said, well, I didn't read it, but on the top of the first page said application. He was misunderstood what exactly the document was. And the court said, it doesn't matter. It doesn't matter whether you thought you were signing something else. And the quote that was provided by the Hoffman court is, failure to read the guarantee and not excuse his personal liability because, quote, belief as to the nature of a document that he did not read did not relieve him when such belief was not brought about by the misconduct of the other party.
Right.
So
wouldn't that be the distinction, though? I mean, if a consumer goes into a health club and they say, and they tell him,
Sure.
$10 a month, $20 a month for a year, and see or sign the dotted line, just the signature page, and he signs it, and he then finds out it's $200, $200 a month for 10 years. He has a fraud claim.
Sure.
Because you can say there's active misconduct by
Exactly.
the other party. Isn't that the distinction?
It is. It is. And there's actually, I think we cited a case from outside of our jurisdiction where someone signed a promissory note in just signature pages. I believe it was the Wayne case we cited in our brief, where the failure to follow up on those documents did not relieve the note holder of that liability. Again, it wasn't a guarantee situation, but it was a similar thing where you signed this signature page. And regardless of any of the cases from the other jurisdictions, the case law in Arizona is abundantly clear. You don't admit parole evidence when you have a contract with a signature, and that has been proven. And that has been proven in this case, and that was proven from the trial court. And the trial court, on that basis, was fully entitled and appropriately entered summary judgment in this case.
Opposing counsel didn't suggest, he said that we're going to be creating bad precedent in this state if we allow his client to be bound, as I understand his argument, if we allow his client to be bound to a contract that he didn't read because it wasn't attached to the signature page. Is that a fair statement of your understanding of what he said?
I believe that is the gist of his argument, Your Honor.
What is the difference legally between having a contract with a signature page attached, signing the signature page, and not reading the contract, as opposed to signing a signature page and not reading an agreement that's not attached, but understanding it's going to be attached to something. What is the difference in legalese?
It's a distinction without a difference, Your Honor. Whether I don't know what I'm signing because I choose not to read it, or I don't know what I'm agreeing to because I'm not sure what my signature is going to be attached to, it's the same legal concept. You're providing your signature to an agreement, you know you're providing it to an agreement, and whether you choose not to read a document that's placed in front of you, or you choose not to ask for the remaining pages, it's the same gross negligence. It's the lack of knowledge. It's the lack of, I am not going to give you my signature until I know what this is going to be affixed to. And that's entirely on them. So that's how I would see that distinction.
Right, and the protection for the signer is, gee, if there's any issue of misconduct, like they misrepresented what I was signing, or I asked for it and they didn't give it to me, then you got an issue. Because then that could be fraud it could be fraud in the inception.
Sure.
Which could lead to a rescission of the agreement. But I think your answer also goes to my question, which was, and I think it answered it. What's the difference between saying I'm going to sign something sign a signature page without reading the documents that are attached to it, or I'm going to sign a signature page without asking to see the documents that it's going to be attached to?
Right. It's the same effect, because under the law, under the substantive contract law as articulated in Bradley, the law gives strong meaning to that signature. And again, you know, there's a lot of things he claims his client should have done. Well, and would have not done if they would have known. Well, the only way they would have known is if they would have asked and made sure that I'm giving you a signature for an agreement, for a loan that I want. And I'm signing documents that say I'm going to be a personal guarantor, an individual guarantor. And now to sort of say, well, wait a minute, I was under the misperception. No one told me this. No one told me that. No one has a duty to tell you that. You have to determine that for yourself. And that's why I do think the court correctly applied the existing Arizona law in this case, and that the factual distinctions that the appellants are trying to make here are really irrelevant to what the law holds. So there's a couple other fact issues I could correct from opposing counsel, unless you have any questions.
Go for it.
All right. Well, one of the questions, or one of the issues that they raised, was about this tenant in common agreement, and it's the transactions and the background of the transaction before the actual execution of the loan documents. It goes back a couple years. It was a 1031 exchange. But one of the interesting documents, which they utterly ignore, is there was a fax from Mr. Weiss to Mr. Bayman, and it is at the record 198. It was statement of fact 12, which was identified in our motion for summary judgment on liability issues. And in this fax, Mr. Weiss admitted that he sent a fax to Mr. Bayman, and he says, subject to any requirements of any first mortgage lender and any mezzanine lender, the Bayman Company shall cooperate with the Weiss Group to make the investment in a manner that endeavors to qualify the investment for the benefits of a Section 1031 like-kind exchange. I'm going to skip ahead a bit. It says, it is contemplated that the Weiss Group entities will acquire a tenancy in common interest in each property. And then at the very end of this fax, it reads as follows. As a co-owner, the Weiss Group's entities will cooperate in signing the same notes and loan documents that the Bayman companies are required to sign with the first mortgage lender and the mezzanine lender. Now, that obviously doesn't say Sam Weiss individually. It says the Weiss Group entities, et cetera, like that. But it's clear from that fax that Mr. Weiss wanted this loan transaction, and he was talking with Mr. Bayman saying, I'll sign whatever you want to sign, and we'll cooperate with that. There was no, this entire concept of well, there can be no meeting of minds because Mr. Weiss voluntarily signed all these documents, again, is belied by the entire history of the transaction. And so to argue that he thought it was one thing and it is now something else, it really isn't true. And that's frankly even belied by, as I indicated to you, the guarantor certificate, which clearly, there's no dispute on what signing that document meant. There was a personal guarantee, he knew it, and there's no other issues that can detract from that. And there's no issues of fact for the jury in this case, because there is no jury. This was a bench trial. The court looked at all the facts and understood.
It was a summary judgment.
Yes,
Okay.
but there was going to be a bench trial should
But that's still different than a summary judgment.
Sure,
Because then
sure, I
there's
understand.
credibility issues that come into play.
Right, I understand. But as a matter of law, I'm taking all the facts, and again, I guess the last issue that's really important to look at in this case is what is the objective evidence in this case? It doesn't matter what Mr. Weiss thought. It doesn't matter what he hoped. Those were all subjective intent issues. Mr. Weiss could have thought, he could have read whatever he wanted into, but what you and what the court below is required to do is look at the objective evidence of what happened here. There was a party who wanted the loan transaction. There's a party who provided a signature for certain loan documents and agrees that they're enforceable, and other loan documents in the same manner he disagrees with because he subjectively did not want to believe that to be the case. It is under Arizona law his burden. We have satisfied in determining what the contract is, proving up what its contents are, and all the other facts attendant to summary judgment in this case. And because of that, I think the court below should be affirmed in all of its rulings in this case. I have additional time, but unless you have some questions, I'll.
Yeah, I have one. Go for it. There's nothing on the merits, but you didn't request attorney's fees on appeal. I was wondering about. I mean, and it's too late now because
Sure,
the
I
new
understand.
rules say it has to be in the answering brief.
Your Honor, my client continues to pay my bills, and I have got a multi-million-dollar judgment. A multi-million-dollar judgment plus attorney's fees. At some point, you say, how much money am I going to spend? I still have to go try to collect something. And so, notwithstanding the fact that my client would have been entitled to fees in this case, I think it was fair to say that the cost of proving up a fees, and you got to remember, this case, Your Honor, took 3 years. At some point, my client wants to get their judgment and move forward.
Okay, so they're just saying, your answer is that it cost effectiveness is.
Yes, exactly.
They sort of ask for the fees.
Exactly.
All right.
Thank you, counsel.
Thank you.
Counsel brought up an interesting point about looking at the witnesses and how they testified. I think it's imperative to look at how their own 30B6 witness testified, Dmitry Solsky. Key testimony that he provided, he said very clearly on the record during his deposition that Samuel could not be bound unless they actually presented Samuel with the guarantee so he knew what he was guaranteeing.
Now, who is this?
This is their 30B6 witness, Dmitry Solsky.
I'm sorry, where's that in the record? Would you identify that in your brief? I mean,
It's in the
okay, so this is the deposition of 30B6.
He also acknowledges there was no lender there. There was no discussion of the loan. Their only witness testified there was no meeting of the minds. There was no specification of the terms at the time of the document was signed.
Now, wait a minute. So a person who was not present at the time this was signed, we don't have any information indicating he was present at any point.
Well, what I'm saying is he's their only witness. He's
And then came in and said there was not a meeting of the minds.
He said that my client would have to have had the personal guarantee in order to be bound by its terms. That's what he testified to.
Did he give you any case law for that?
This is just his factual testimony. So So, also look at some of the other witnesses. Bayman, he acknowledges that my client was not made aware of personal guarantee. David Taylor, also testified that my client was not aware of a personal guarantee. Nothing was ever discussed. The attorneys at the Dreyer Law Firm, Carolyn Austin, she testified that she never spoke with him, that she never talked to him about the personal guarantee. No personal guarantee was ever presented to him. Look at the requests for admissions that were signed by the plaintiff in this case. They acknowledge they had no eyewitness testimony to the signing of the loan documents. They also acknowledge they have no personal knowledge that Samuel was told anything about anything that he was signing at the time he signed the signature pages. And they also want to point out the expert witness. Well, let's look at what my expert witness said. She pointed out that this document that had been sitting in their file for 8+ years, when she got the chance to review it, guess what? It had no staples. There's no staple marks on it. So it would be very easy for someone to slip a signature page on it. She also acknowledged that the numbers on the actual guarantee did not match the signature page. On the front page, there's also a document stamp, which is not on the other pages, including the signature page, most importantly. She said that she testified that this is an indication of the signature page substitution. They had no evidence and no witnesses to contradict that expert witness testimony. But yet the court still found that there were no genuine issues of material fact and dispute. We believe the trial court erred, and it's a domino. Once you find that the trial court erred in finding that there was a contract, the court should also find that there was the form selection clause was not enforceable. Should also find that my client did not waive service through the contract, and also ultimately that the damage award was completely inappropriate. And I thank you for your time.
Thank you, counsel. We are going to take the matter under advisement at this time. We will rule in due course. Counsel, thank you very much for your time and for your argument today. We stand adjourned. Thank you. If the next matter